everyone. This is Tom Fox, and I'd like to welcome you to episode 172 of the FCPA Compliance and Ethics Report. The FCPA Compliance and Ethics Report is sponsored by Advanced Compliance Solutions. Today we have back a real treat for you, Scott Killingsworth, and unfortunately the subject may not be as much of a treat because it is a recent Securities and Exchange Commission enforcement action regarding the personal liability of a Chief Compliance Officer. It's called the SFX case, and Scott has written on this case. He talked about the change, or at least appearance of a change by the SEC in focusing on Chief Compliance Officers where they did not engage in intentional conduct. He reviews the facts, and we have some Q&A back and forth about what it might mean in the anti-corruption space going forward. The episode comes in at just over 21 minutes. I hope you enjoy it. Thank you very much for listening. Hello, everyone. I'd like to welcome you to this episode of the FCPA Ethics Report. Today, I'm really pleased to have back with us our good friend Scott Killingsworth. Scott has recently written an article and studied up on a case which he thinks has some significant implications for compliance practitioners and chief compliance officers. The article is CCO Liability, Winds of Change at the SEC. It was posted, at least where I saw it, on the Compliance and Ethics blog at the SCCE, and asked Scott if he would come on the podcast and talk to us about it. And so he graciously agreed to take some time to do so. With that somewhat long-winded introduction, Scott, welcome back.
Thank you, Tom. Glad to be with you.
So, Scott, we've got an SEC administrative proceeding with an administrative order in a matter called SFX, Financial Advisory. You think this is significant for our anti-bribery and anti-corruption world, so why don't you walk us through the facts of the case?
Well, I think it's significant for any company that's regulated by the SEC, for sure, and the FCPA certainly encompasses a lot of companies like that. It's about a case where a chief compliance officer of this company, SFX, had to pay the SEC $25,000 to settle a charge that his failure to effectively implement a particular compliance policy amounted to a willful violation of the Investment Advisors Act. Okay, the company gives investment advice. It's an investment advisor, but they also provide bill-paying services for their clients. And the president of the company was handling those accounts, and he embezzled about $670,000 from some of the clients. He had signature authority over the accounts, and he was writing checks to himself and to related entities. And nobody else at the company was reviewing his work or auditing the money as it flowed in and out of the accounts. So what the SEC said was that the president was able to circumvent review of those accounts by the CCO. And we don't know exactly how he did that. The order doesn't say. But in a way, this case is about whether a CCO should be held liable if the top officer is able to circumvent controls the way this guy did.
Scott, before we go any further into the specific facts of this case, in your article you cite a speech last fall by Andrew Serezny, head of enforcement for the SEC, where he talked about the danger zones for chief compliance officers. And he said that chief compliance officers should be concerned, or at least we're in danger zones of SEC enforcement when compliance personnel have effectively participated in the misconduct. So we have actual willful misconduct or participation. When they have helped mislead regulators, clearly another situation where I think that would be a willful nature. And when they have clear responsibility to implement compliance programs and policies or wholly fail to carry out those responsibilities. In your article, you detailed the three components of liability against the chief compliance officer, saying he did not effectively implement an existing compliance program. He failed to ensure that cash flow reviews were done by someone other than the president, and that there was a statement on the company's brochure, which the SEC found to be untrue. And then finally, in the midst of an internal investigation following the discovery of the president's misappropriation, SFX did not conduct an annual review of its compliance program. Could you perhaps unpack each three of those allegations, at least as you read them in the SEC order?
Sure. Not effectively implementing the existing compliance policy was just that he did not effectively get to review all these accounts. And we don't know exactly how. He may have reviewed a sample of accounts the way you do in a lot of audits and missed the three accounts that were embezzled from. But the review wasn't effective, which is to say he didn't detect this, and he didn't review every account. So that's number one. Number two, the thing about the brochure being false was the brochure said that all the accounts were reviewed frequently by senior officers of the company. Well, let's face it, the president was handling those accounts, and he is a senior officer. But the SEC felt that the fact that it wasn't independently reviewed by somebody else made that statement in the brochure false. And maybe they're right. You can interpret it that way. But it feels like a reach to me. And then the third thing was the SEC went out of their way to say in the midst of the internal investigation of the president, they skipped the annual review of compliance program and policies that's required by the Investment Advisors Act. So, I think most compliance officers out there, if they had a choice to do an annual review or to investigate the president's embezzlement, they'd probably prioritize the president's embezzlement. And that's what this guy did, and so they got him for it. So the first charge is that he didn't effectively implement policy, and certainly he didn't catch the CEO, the president. The other two just sort of feel like make-weight things. You made a statement in an existing brochure false because you didn't effectively implement your policy. And by the way, you're investigating the president, so you didn't get your review done. And we don't know anything about how many resources this CCO had, whether he was a solo one-person department or not, but I suspect that he was. And it's kind of hard to investigate the CCO and do a policy review at the same time.
Scott, the reason I kind of read those remarks by Andrew Seresny and then talked about it in terms of willfulness is I didn't really see from the SEC order that level of conduct, of nefarious conduct by the chief compliance officer. Did you see anything which rose to the level of willfulness, or is that really one of the questions you have in your mind?
No, in a common sense use of the term, no. Did he affirmatively participate in the misconduct? Absolutely not. Did he help mislead authorities? No, he reported it to the authorities. He investigated it and reported it to the authorities. And then the third criteria in Seresny's speech was wholly failing to carry out your responsibility to implement compliance programs or policies. Well, he failed to carry out one policy effectively, and that was reviewing this particular set of accounts and catching it. So I don't think he met any of the criteria in Seresny's speech, and so this feels like either a change in policy by the SEC, or if it's not a change in policy, maybe there's some facts that we don't know. And if the facts are worse than what they put in the order, the SEC ought to come out and explain that to us and show us how this fits within what we thought was the SEC's enforcement policy.
Scott, you can really turn, I pride myself on being able to write well, but you can really turn a phrase when you sit down and write. And one of the phrases that struck me was that you said financial services CCOs are often the canaries in the coal mine. What
right.
do you mean by that?
Well, that's a phrase that means they're the first ones to feel it when something goes wrong. If you have a canary in a coal mine and there's methane gas, the canaries die before the miners do, so the miners can get out. And in the case of CCOs, what you've got in the financial services industry is an industry where every transaction you do is subject to regulation. A lot of the transactions need to be constantly monitored on a routine basis. It's an industry where there are a lot of specific requirements to implement particular types of compliance policies or procedures, like the filing SARs under the anti-money laundering statute. So, it's not like most unregulated companies where you have the sentencing guidelines to guide you. and they're in some sense voluntary. It's cases where there are statutes telling you have to have certain types of policies and you have to do certain types of reports and disclosures, often directly to the government. Plus, in the financial services industry, there are statutes and regulations out there that say you have to appoint a specific person who's in charge of implementing these policies, which is often the CCO. And that's what one of my partners used to call a designated jailee. You know, you've got to designate who's going to be in trouble if things go wrong in this particular area. So all that sort of amounts to a special type of industry where compliance officers are more exposed than they are in the typical industry. But I think what you see if you've been in the law business for any amount of time is you see enforcers in one domain getting hints and getting ideas from enforcers in other domains. And if this really is a change in SEC policy, the concern is that we'll see this propagating to other regulated fields like antitrust, things like that. So, it could have implications that are broader than just the financial services industry.
Well, I guess that's where I draw the distinction, perhaps from you, because I see this as really limited to a highly regulated industry, those subject to the Investment Advisors Act of 1940, that sort of regulation, not to the more general U.S. public company standard, certainly under the FCPA. I'm not an expert in antitrust enough to know or even comment on whether that's regulated, but I just I don't see the sort of slippery slope that you potentially see for ABC or anti-bribery, anti-corruption compliance officers. But nevertheless, what do you see?
Well, you may be right, Tom, but just think in terms of the books and records provisions. What if you're out there and you've got what you think is a good set of accounting controls and you think they're being administered well, but as a CCO you're not necessarily an expert in this, and it turns out there was a hole where you didn't, quote, effectively implement your financial controls. And it seems worrisome to me.
Well, I guess I don't see that as a liability of the CCO. I would see that as the way the FCPA is written, the responsibility of the company.
Right.
But I do agree that certainly in the books and records, accounting provision, including the books and records and internal controls, is closer to a strict liability standard under the FCPA. But if we sort of took that and played the great lawyer game of the slippery slope, what I try to communicate to clients is I've not ever seen a company prosecuted in the FCPA space for being negligent. There has to be some sort of willful act. But this case would seem to point to a something less than a willful act by at least the CCO of SFX, and that I guess you're saying that this could be a change down the line. Is that a fair statement?
It could be, and also under some of the securities regulations, there are some cases out there that say that negligence is enough to trigger a willfulness standard in some of the offenses that don't have a criminal intent requirement to them. So negligence equals recklessness equals you're in trouble in some of these cases. And that is a specific piece of case law that's out there.
Yeah, if you could go from negligence to recklessness, it's not too many steps further down to either conscious negligence or willfulness. So
right.
Absolutely. This change, one of the criticisms, or perhaps that's too strong a word, but certainly commentaries about the FCPA is we see the change in enforcement focus without really either an announcement from the regulators, be that Securities and Exchange Commission or the Department of Justice, or really an explanation in the settlement documents, whether they're in the form of a deferred prosecution agreement or others. Is that one of the concerns you have in this area, that we have a speech as recent as October, and here we have conduct that would appear to be outside what the directive of enforcement said?
Yeah, I think anybody who is in a CCO or compliance officer role of any type needs to be aware of what they need to watch out for in watching their own backs here. And if we can't rely on what the SEC is publicly saying out there, if they can change enforcement priorities just because they want to win a case, which may be what happened here, it just adds uncertainty to the situation. And remember, compliance officers, Steve Cohen said in a speech last year that he feels like we're playing, actually it was this year, he feels like we're all playing for the same team. We're in the same line of business as the SEC. We shouldn't have targets painted on our backs. And it just seems to me that the least you're owed as a matter of common courtesy is let us know where the line is that we need to be working on to protect ourselves.
Well, and actually you've foreshadowed the next area which I wanted to get into was precisely that many CCOs feel aligned with the regulators and the Securities and Exchange Commission and Department of Justice, and they certainly see CCOs and compliance practitioners as the last line of defense for a corporation. And if there's a change in that sort of relationship, I think that could be very troubling for really anyone in the compliance field if they're going to start going after the compliance practitioner who does not engage in willful or reckless conduct.
Right, and there's two really big policy issues here. One of them is, when is it fair to hold me liable for failing to prevent or detect somebody else's misconduct? Right? That's a tough policy question by itself, and it's a tough question of justice. And then the other policy question is, what should the SEC be doing in enforcement vis-a-vis compliance officers that will maximize the effectiveness of the in-house compliance people? And there's every reason to believe that if you crack down on a hair trigger basis on compliance officers, you're going to be driving people out of the profession, or you're going to be putting them in the position of being Dr. No, which does not really help you function effectively inside an organization. So I'm not sure this is good for the SEC, even if they can win a lot of cases by doing hair trigger prosecutions of CCOs.
I once heard Chuck DeRoss, when he was with the Department of Justice, say that he viewed chief compliance officers as the Alamo, and he actually meant it as they're the final line in the sand. And so I gingerly raised my hand and said, Chuck, being a good Texan, I certainly appreciate that, but everyone at the Alamo got slaughtered,
right.
And everybody got a good laugh out of it. But it seems to me that if the FX logic is extended to non-regulator areas, we could be moving towards more of that slaughter than this being a last line in the sand. Because in every last stand case, the same thing happens to all the defenders. They all lose their heads. So anyway, very interesting set of cases. Are there any other cases you have seen or even heard about which you have given you pause in thinking along these areas?
Well, there's a lot of cases out there, and you see a headline every couple of weeks, but I think that most of the cases out there should not be troubling for most compliance officers who are out there really trying to do their job and doing the best they can. I mean, a huge number of the cases have to do with people actively participating in misconduct. A number of the cases involve giving false reports to the government, or falsifying reports, or filing untrue statements, or not keeping promises that you've made to the government with respect to remediation. A number of cases out there, quite a few of them, involve people that Roy Snell would say, these are not CCOs. They're people who have the CCO title, but might also be the founder of the business, the CEO of the business, the majority owner of the business. They took on a CCO title because it's a 3 or 4 person business if they're running themselves, and they committed their violations mostly in the guise of their CCO or their CEO or their owner role. So there's a whole lot of cases out there that you really shouldn't worry about if you're trying hard. There are some troublesome cases, but a lot of them like this have to do with very specific types of FINRA or SEC violations that are, where you have a really well-defined area that you need to be doing well-defined things in, and people are not doing those things. But even in most of those cases, Tom, it's not doing it well. It's failing to have policies and procedures. So, for the most part, people who are acting in good faith and trying to do their job don't have a lot to worry about.
One of the cases that got a lot of discussion at Compliance Week 2015 was the indictment of the former CCO of Alstom in the United Kingdom.
Right.
Unfortunately, no one really seemed to have any idea what the underlying facts were, so we're engaging in the lawyer's favorite topic of rank speculation, not even just regular speculation. Have you heard anything which would give you pause to consider that case as something that CCOs need to be cognizant of?
I am just like you, and the press descriptions that I've read of that case don't tell me enough to really to make a judgment about it. But I think there's an article in Compliance Week this week about how the UK is taking CCO liability a lot more seriously than even the U.S. regulators are. And for those who are in multinational companies and to travel a lot to England, that's something you maybe ought to bear in mind.
Well, Scott, it's always a pleasure to visit with you. You've consistently come out with thought-provoking articles that lead many of us in the compliance space to think more and more deeply about what we do and how we do it. So I appreciate you taking the time to visit with us and look forward to continuing the conversation.
Great, Tom. Thank you. I appreciate speaking with you.
All right. Thanks a lot. Hello, everyone. This is Tom Fox again. I hope you enjoyed this episode of the FCPA Compliance and Ethics Report. As a call to action, I would ask you to go over to iTunes and rate this podcast so it can help our ratings on iTunes. Also, I'm compiling a list of questions from our next mailbag episode, so if you have any questions, please email them to me at tfox@tfoxlaw.com. I hope you've enjoyed this episode, and I look forward to visiting with you again next week.